Be ready. 5 seconds.
Since the issues raised in both the captioned appeals are same and the challenge is also to a self-same judgment and order passed by the High Court, those were taken up for hearing and are being disposed of by this common judgment and order. Stop. The present appeals arise out of the final judgment and order passed by the High Court of Judicature at Madras in criminal original petition filed by the respondent number 1 bracket accused bracket close herein under section 482 of the Code of Criminal Procedure, by which the High Court allowed the petition and thereby quashed the charge sheet filed for the offences punishable under section 67B of the Information Technology Act and section 15 bracket 1 bracket close of the Protection of Children from Sexual Offences Act. Stop. As a consequence, the criminal proceedings stood terminated. Stop para. It may be necessary to clarify that the appellant number 1 herein, single quote, Just Rights for Children Alliance, quote close, is a coalition comprising of 5 different NGOs that work in unison against child trafficking, sexual exploitation, and other allied causes. Stop. Whereas the appellant number 2 is a child rights organization working towards protecting children from exploitation and one of the partner NGOs to the aforesaid coalition. Stop. The appellants herein were not a party to the proceedings before the High Court. Stop. However, having regard to the serious issue of public importance involved in the matter, they sought leave of this court to challenge the impugned judgment of the High Court. Stop para. The learned senior counsel appearing for the appellants submitted that the interpretation of the relevant provisions of POCSO by the High Court for the purpose of holding that mere storage or possession of any child pornographic material does not amount to an offense, poses a significant threat to the well-being of children and may result in proliferation of child pornography, posing a significant threat to the very social fabric of the society at large. Stop. In support of his submissions, he relied on the Convention on Cybercrime and the United Nations Convention on the Rights of the Child. Stop. He further submitted that the charge sheet filed by the investigating agency specifically records that, as per the information received from the National Commission for Missing and Exploited Children, USA, the accused had been watching child pornographic videos for the past 2 years. Stop. He further contended that the High Court erroneously proceeded under section 14 bracket 1 bracket close of the POCSO, which deals with the use of children for pornographic purposes, without giving due consideration to section 15 bracket 1 bracket close of the Act. Stop para. The Parliament should seriously consider to bring about an amendment to the POCSO for the purpose of substituting the term double quote child pornography quote close that with double quote child sexual exploitation and abuse material quote close with a view to reflect more accurately on the reality of such offences. Stop. The Union of India, in the meantime, may consider to bring about the suggested amendment to the POCSO by way of an ordinance. Stop. We put the courts to notice that the term double quote child pornography quote close shall not be used in any judicial order or judgment. Stop para. For all the foregoing reasons, we have reached the conclusion that the High Court committed an egregious error in passing the impugned judgment. Stop. We are left with no other option but to set aside the impugned judgment and order passed by the High Court, and restore the criminal proceedings to the Court of Sessions judge. Stop. We accordingly pass such order. Stop.